Whenever you're ready.
Good afternoon, Madam Clerk. I'll reserve 5 minutes, please, for rebuttal. Good afternoon. May it please the court. My name is Jasmine McMackins Hatcher. I represent the appellant in this matter, Ms. Katelyn Taylor. Your Honors, this matter arises, it's a request for post-conviction relief that Ms. Katelyn Taylor filed in the Benton County Circuit Court back last year sometime. I was appointed to represent Ms. Taylor by the court in that post-conviction case, represented her at the trial below, and of course represent her now on appeal. Before I get too far into the facts of this case, I'd like to have the court go back in time with me to March of 2020. If the court will recall, that was the onset of the COVID-19 pandemic. Following the onset of the pandemic, there were obviously a series of governmental shutdowns, including to the judicial system. You know, at that time, most attorneys and probably judges knew there would be some impact to the cases that were pending during that time. You just really didn't know what that impact would be. I start here to ask the court to use that as the backdrop as you look at the facts of this case and the alleged errors that Ms. Taylor presents to the court regarding the effectiveness of her counsel and the constitutionality of the plea that she entered in her case. Again, if you use COVID-19 and the pandemic as the backdrop, a lot of the alleged errors, I believe, will make much more sense to the court. The barriers that were placed between lawyers and their clients, the impairment to contact between lawyers and clients, the slowing of the judicial process, if you will, all of those things came into play and impacted the ultimate outcome of this case. Essentially, Ms. Taylor was arrested on or around March 23rd or so of 2020 for the killing of Eugene and Celeste McDaniel, which were her grandparents. The initial arrest documents cited criminal homicide, sort of a catch-all, if you will, statute for the state in the state of Tennessee. She remained in custody continuously following her arrest. She was able to have a preliminary hearing before the Benton County General Sessions Court in June of 2020. She had appointed counsel. That was the public defender, local public defender's office, specifically an attorney, Paul Hessing, was her attorney in those proceedings. At the conclusion of the preliminary hearing, the court found probable cause to support 2 counts of second-degree murder, and that was ultimately what she believed she was being bound over to the grand jury on, 2 counts of second-degree murder. I'd submit to the court, to some degree, Ms. Taylor understood what that meant. She likely understood there was first-degree murder, and then there was second-degree, and that there were even likely some lesser homicide offenses, even from second-degree murder. She was remanded back into custody at the Benton County Jail, where she remained until October of 2020. Now, from June until October of 2020, the trial counsel admits that they likely had no communication with Ms. Taylor. I don't say that as part of my criticism of their representation of her. That's just somewhat common between the preliminary hearing and the presentment to the grand jury, especially for the local public defender's office. There's oftentimes not any real development in the case. The case is no longer pending in general sessions, and it is waiting indictment. So it is very likely, and they acknowledged that, trial counsel acknowledged that it was very likely that they had no substantive communication, probably no communication at all with Ms. Taylor. Going back to that COVID-19, there really wouldn't have been any reason to go into that jail during that period of time unless something had arisen, and there was no recollection in testimony that anything like that had arisen.
Ms. Hatcher, I
Yes.
appreciate the argument. I've read the briefs.
Yes.
Do you have a response to the state's argument about your failure under Rule 27 to cite to the record in this case?
Certainly, I would have not been very prepared if I didn't come here prepared to respond to that. I did see that the state was critical of the brief and the lack of technical citation. My response to the court would be that the brief, again, I did represent Ms. Taylor in the trial court proceedings, so I had an actual working knowledge of the content of the record. It was very voluminous. I believe the trial transcript alone was 700 pages, made up of 5, maybe 6 volumes. and then another 3 volumes of exhibits. I would submit to the court that the entirety of the appellant's brief is content from the record. It is not as if the brief makes claims or cites evidence that is not contained in the record. It just lacks the
But
technicality.
the purpose of the rule is twofold. One, what you addressed just then, and that is to make sure that what you're saying is contained in the record. But the second would be what you mentioned as you first started. This is a large record, and how are we supposed to find what you're referring to and the testimony surrounding what you're referring to if there are no citations to the record in your brief?
And certainly I understand the court's concern, and that is the reason for the rules. I can only submit to the court that where the brief is lacking in some of the technical requirement, it has an abundance of substance, and that is what the arguments that Ms. Taylor submitted at the trial court, they are present, substantively supported by facts and evidence that your honors do have the opportunity to review the record, and all I can say is that I can assure the court that the information contained in the brief is supported by the record. Again, I know that having represented the defendant in the matter and having the opportunity to represent her in this appeal. Going back, I think I was at October in the timeline. Finally, the case was presented to the Benton County grand jury. Once that happened, Ms. Taylor was video arraigned. Again, that was a COVID-19 protocol. She appeared before the Benton County Circuit Court for the first time, so now we're from March to October, first time being back in a courtroom since June, and she hears that she had been indicted by the Benton County grand jury on 2 counts of first-degree murder. Again, going back to that record and the testimony of her counsel, they acknowledge and admit that that is very likely the first time that she would have known that. They had no recollection of telling her that the Benton County grand jury had indicted her on first-degree murder. So she hears that information for the first time, again, via video arraignment, not having access to her counsel. She is again remanded back into custody at the Benton County Jail, where she has to await her lawyers to come and see her. They do eventually come to meet with her. Both of her trial attorneys acknowledged that there was one substantive meeting from October to late November, and during that meeting it was brought to Ms. Taylor's attention by her counsel that she had apparently made some very incriminating statements to some cell inmates, and her attorneys expressed frustration with her. At the conclusion of that meeting, the holidays came about, and like most courts and lawyers, there was a break taken. On November 27th, Ms. Taylor reached out to her defense attorney, Attorney Taz Gardner, and wrote him a letter essentially asking him to come back and speak with her about her case. She was concerned about the outcome. In that letter to him, she did write that she would be willing to enter a plea of guilty by way of insanity as in exchange, if you will, for a sentence of life with parole. She does say in that letter, unless he advises her to do otherwise. So this is her way of saying to her counsel, I'm open to your advice. If you have any other option for me, please come to me and give that to me. Otherwise, it appears that I need to be starting to look at other options.
Ms. Taylor, let me stop you for a second.
Yes, sir.
Because what you're saying, I mean, the judge heard from your client as well as from the defense attorneys in this case, and found your client to not be credible, and found the lawyers to be credible. So, you know, we're now looking at this from the standpoint the judge has made a credibility determination, which we have to take, you know, unless the record undermines that finding, which, you know, it's, but obviously the attorneys had a much different take on this than what you're saying, in that you know, your client was contacting the DA, wanting to plead guilty, was contacting the TBI, wanting to work out a guilty plea. The lawyers tried to talk to her about trying to get some more information and do some more work, but she was very insistent on wanting to get this case over with.
Yes, Your Honor. I'll try to address the points that you make. First, regarding the credibility issue, certainly Ms. Taylor did elect to take the stand and testify to the court, as I think she needed to express her concern with her representation. The court did make a credibility finding that the well-respected lawyers in her case were more credible than her. I do want to point out where there is support in the record why that should be undermined. The attorneys for Ms. Taylor testified that they had no recollection of Katelyn Taylor ever expressing any concern to them about the possibility of receiving the death penalty. I submit to the court that makes no sense whatsoever.
Let me stop you for a second, because
Yes.
from what I've read through the record, there never was, apparently, the state never said they were going to seek the death penalty.
The state had not filed the death notice, but that all goes back to the big issue in this case. There had been no time. Ms. Taylor had just been indicted at the end of October. She started negotiating this plea about 25 or 30 days later. So there really had been no time for the state to file that note. Now, certainly they could have. They could have filed it on day one, but they're certainly not required to file it until much, much later in the process. I believe it's actually 10 or 15 days prior to the trial. So again, you kind of hit on the issue of time. Everything was drastically expedited by Ms. Taylor. The same day that Ms. Taylor wrote that letter to her attorney, Taz Gardner, she secured access to a cell phone from the Benton County Jail. It's the November 27th. That's the day that all the communications essentially started. She sends a text message to what she hoped would reach the hands of TBI investigator Joe Hudgens. Lo and behold, she's successful. He does receive the text message from her from the Benton County Jail. She tells him, "I'm Katelyn Taylor. I'm at the Benton County Jail. I would like to speak with you." Investigator Hudgens takes some action after receiving that. He contacts the district attorney prosecuting the case. He actually also responds to Katelyn Taylor. He sends a message back to Ms. Taylor through the jail administration stating that, "I can't speak with you because you're represented by counsel." General Hedge, which is the district attorney, contacts defense counsel who are out of town for Thanksgiving and says, "Hey, your client is at the Benton County jail trying to speak with us." Both attorneys tell General Hedge, "We're out of town, we're not available, we will be out to see her next week." Now, I think most lawyers practicing criminal defense would feel somewhat confident that everyone would back off, that the state would have backed off and that the investigator would have backed off. But they certainly did not back off. What Investigator Hudgens proceeded to do was to send messages to Ms. Taylor telling her, "I can't speak with you, I can't come to the jail because of COVID-19, but you can write me letters. You can confess. You can tell this family what you did. You can bring solace and peace to this family by writing me a letter confessing what you've done." And then he even goes as far as telling her, "You can pray they have mercy on you. You can hope that they would agree to a life sentence." And then going back to that comments about nobody ever mentioned the death penalty, well, when you have Investigator Hudgens telling you via letter, you can hope that they'll agree to life, it's opposed to death. So certainly these are all things that are going on and everything is happening very quickly. But at this point, Katelyn Taylor is officially taking the guidance and advice of TBI investigator Hudgens and not her attorneys. This is where counsel was ineffective. At no time did either one of those gentlemen reach out to Ms. Taylor at the Benton County Jail and advise her to stop communicating with the district attorney and the investigator prosecuting her.
Which she did by choice.
She certainly did that by choice. And that was one of the things we did submit to the court. Certainly the plea, the negotiations, the conversations were voluntary. It's really the knowing aspect of the plea that we believe was unconstitutional, making it
What
void.
was unknown?
Yeah.
What are you alleging was unknown?
Everything. She certainly had no time. She had not been presented with the discovery from her attorneys. They had not reviewed.
But if I remember, their testimony was that they were the ones trying to slow her down, and she was insisting on, because she wanted to get this over with, she didn't want to burden her family, and all these other issues, that she wanted to go ahead with this. So how is it the lawyer's fault when she basically has her own agenda and wants to do it a certain way?
One of the things that I want to take some opportunity to respond to that, the lawyer's fault. So Attorney Paul Hessing testified that he was lead counsel. He even went as far to say if there was a decision to be made, it would be him to make it. If there was advice essentially to be given, he would be the one to give it. But for some reason, once those November 27th communications started and were initiated by Ms. Taylor, Attorney Gardner takes over, and Attorney Hessing actually never provides any additional counsel to her for the remainder of the case from the time that she going forward to entering the plea. So I also think that is part of the ineffectiveness, is that the lead counsel, the counsel charged with the responsibility of reviewing the evidence, assessing the
You've got
facts.
two lawyers, obviously, and both of them, I would say both of them have that responsibility if they're co-counsel.
They were not co-counsel. The dynamic between the two is that Attorney Hessing is the assistant public defender, and he was essentially assigned to the case, the representation. You've got Attorney Taz Gardner, who is the elected public defender, who I guess manages Attorney Hessing's work.
Well, he's also
The elected public defender. My time has ended. Anything that I can address now?
Good afternoon, Your Honors. May it please the Court, Davey Douglas on behalf of the state. This Court should affirm the denial of post-conviction relief in this case. And as an initial matter, as was first discussed, this Court should find that the arguments and issues raised are waived due to the failure to cite to the record in the appellate brief. As was discussed, this is a voluminous record. It's over 5 volumes, I believe, of transcript alone, and there are numerous attributions to statements of both attorneys that are not supported by any citation to the record. And it's not the role of this court to sift through a record to find support for assertions that are made in the brief. So for that reason alone, this court could deem that the petitioners waived the issues. But even if the issues are not waived, the petitioner is not entitled to post-conviction relief. As the post-conviction court found, the reason that the petitioner and her attorneys didn't have more time to investigate the case was of the petitioner's own choosing. She was the one reaching out to the district attorney and to the TBI and soliciting these plea offers, which the district attorney then provided. And the petitioner can't basically short-circuit counsel's investigation and then blame them for not conducting a more thorough investigation. And even with the time that they did have, they were still able to investigate the evidence in the case. They were able to meet with the petitioner and discuss her options with her. Both attorneys testified that they received discovery from the state and that they reviewed it, and it included some pretty incriminating evidence. There were multiple statements that the petitioner had made to jail inmates in which she described details of the crime that only the perpetrator could have known, in which she admitted to committing the crime. There was also the gunshot. She tested positive for gunshot residue, which contradicted her claim that she only used a knife. And counsel, having reviewed all of this and discussed it with the petitioner, agreed that it was a substantial amount of evidence against the petitioner. But then, most importantly, once the petitioner actually got the offer from the state, Mr. Gardner came down to the prison and discussed that offer with her. He provided her with her alternatives to pleading guilty, telling her that she could go to trial. He discussed the length of the sentence with her and what the state's proof would have been at trial, and he then left, giving the petitioner a couple days to think over the offer. And then she declared in open court that she wanted to plead guilty in exchange for the 2 life sentences.
You've obviously read the record because you cited to it, but is there anything in the record besides the petitioner's self-serving testimony or her own testimony talks about the death penalty?
No, Your Honor, there's not. That's the only support for that assertion is the petitioner's testimony, and it's contradicted by the testimony of both attorneys at both the post-conviction hearing and at the guilty plea colloquy itself, where...
That was what I was going to ask you about, is did the discussion about the death penalty come up during the guilty plea?
Yes, Your Honor, I believe it did, and I believe that Mr. Gardner put on the record that Ms. Taylor was not facing the death penalty, that he had accurately advised her that the state could have filed a notice if it wanted to, but that it had not filed a notice at that point. And again, both attorneys testified that they never told Ms. Taylor that she would receive the death penalty unless she pled guilty. They never told her that that was on the table. They never coerced her into pleading guilty. They both said that she actually never made the death penalty much of an issue, that she never brought it up. She never expressed her fear of the death penalty and never said that she was pleading guilty to avoid the death penalty. With the credited testimony of counsel and the additional exhibits and evidence in the record shows us is that the petitioner was aware of the sentence, or the crimes with which she was charged. She was aware of the potential sentences, and she was aware of the evidence that the state was going to use against her. And having had the opportunity to review this and to have discussions with her trial counsel, she then made the decision to plead guilty. She admitted that she knew the charges were first-degree murder. She admitted that she knew the possible sentences. And this court should affirm the judgment and credibility determinations of the post-conviction court and find that trial counsel here were not ineffective and find that the petitioner indeed made a knowing and voluntary guilty plea. And unless there are any further questions, we ask this court to affirm. Thank you.
Thank you. Counsel, your rebuttal?
Yes, Your Honors. Certainly, the crux of this issue is whether counsel's representation of Ms. Taylor was ineffective, deficient performance, prejudice, and whether her plea was entered knowingly and voluntarily. So I'll take the remainder of my time to hit on those three things. Specifically, counsel was ineffective for advising Ms. Taylor to go forward with the plea. No doubt that she set the wheels in motion, but counsel admitted that they did not attempt to stop her. Now, whether the court truly believes that they should have or not certainly will be an issue that Your Honors have to decide. But I will say...
Let me ask you this, though. Whose decision is it to plead guilty?
I certainly believe it's the client's decision to plead guilty.
Right.
I think that has to be an informed decision.
Okay. And the lawyers testified about discussing her with this, and then I think Mr. Gardner was saying that he would not have allowed her to plead guilty if he did not feel that there was sufficient evidence to support the conviction.
I understand that Mr. Gardner testified to that, and I also recognize that he was found to be more credible than Ms. Taylor. However, Mr. Gardner also acknowledged that he was not the lawyer receiving and reviewing the discovery. He was not the lawyer working on the case. So I don't see how Mr. Gardner can testify that he believed that the plea was in the client's best interest, and then also acknowledge to the court that he was not the lawyer charged with the responsibility to review the evidence and to make those decisions, especially when Mr. Hessing made it very clear to the court that he was, in fact, the attorney charged with that responsibility.
Well, and then your client, you know, you're saying that this was done was done with not knowing. Is that correct?
Yes, Your Honor.
Okay. Now, you know, that gets banded around a lot in post-conviction cases, that you know, and usually it's because you have a person that has an 8th grade education and or mental problems. That your client has been to college, was a paralegal.
There was some testimony that she told her attorneys that she had received some study in paralegal services, yes.
But she majored in paralegal studies, and she previously worked as a paralegal.
Ms. Taylor also informed her attorneys that she goes by the name of Harley Quinn. These are all comments and statements that Ms. Taylor was making at the very beginning of the case,
Okay.
that quite frankly were concerning, and
So the lawyer should not have relied on that?
the lawyers testified that Ms. Taylor was very cunning. She was sharp. She appeared to be able to communicate with them. I'm not here to dispute that.
Okay.
I don't think Ms. Taylor knows the difference between premeditated first-degree murder and second-degree murder, despite what education she may have had or what educational level she may have had.
But she did apparently tell the judge she understood it.
In her presentation of her plea, she did answer all the questions in the affirmative as she was entering her plea. The biggest issue is the time. There just simply wasn't enough time for counsel to effectively provide her with the information she would have needed to make the decision to plead guilty to 2 counts of first-degree murder.
But if, as the record seems to suggest, and the trial court accredited the testimony of counsel, she's the one pushing the train down the tracks, it's hard for her to complain about there wasn't enough time.
She is the one who pushed the train. There is no disputing that. On November the 27th, Katelyn Taylor set a very fast wheel in motion. She started contacting anyone and everyone that she can get in touch with.
So what's counsel supposed to do?
I think counsel is supposed to advise Ms. Taylor that this is very early in the process. We are experiencing a national pandemic. Things are going to move slower. You've got to calm down. You've got to give me the opportunity to do my job. I have not explored the filing of any suppression motions. I haven't interviewed any of the witnesses that supposedly have incriminating evidence against you. I've not had time to employ the services of any experts. I have not engaged in a single plea negotiation with the state of
They
Tennessee.
didn't need to, your client was
She
doing it.
had.
She certainly did initiate that process.
I mean, I get your point, but and I'm not saying that the trial counsel didn't do their job, but if your client's the one pushing the guilty plea, there's really nothing the trial judge, the trial counsel can do. And if she answers all the questions correctly to the trial court's gonna accept the guilty plea. I mean, I just don't know where you get relief here by saying she didn't understand because they didn't have time to explain it to her when she's the one pushing the train.
And I certainly understand this court's concerns. It was certainly the concerns of the trial court. I will just conclude my argument by saying that in the absence of any alternative presented to her by her trial counsel, that is a basis for this court to find that the plea was not entered knowingly and voluntarily and can grant her request for post-conviction relief. Thank you for the opportunity.
Thank you. Call the next case, please.
State of Tennessee versus Misty Paul.